Welcome to Next Round with the Pacific Research Institute. I'm your host, Rowena Ichon. In this podcast, our guest is Tim Snowball, an attorney with the Pacific Legal Foundation, a legal organization that takes on pro bono cases on behalf of citizens whose constitutional rights have been thwarted because of government overreach. Tim and I, PRI's Director of Communications, and I chat with Tim about recent legislation in California designed to circumvent the U.S. Supreme Court's landmark Janus decision, which affirms the rights of workers to opt out of paying union dues if they don't agree with their union's political views. You'll be surprised by the tremendous power the unions have in Sacramento and their hold over liberal legislators. Thanks for joining us. Welcome to PRI's Next Round podcast, Tim.
Here, thanks for having me.
It's been about a year since the U.S. Supreme Court made its landmark decision, Janus versus AFSCME, which is a case concerning the power of public sector unions to collect fees from non-union members. So for the benefit of our listeners who may not have followed this case closely, why is Janus so important?
Yeah, absolutely. I'm happy to give that background. Janus was an extremely important case. I think the most important thing for your listeners to understand is really the difference between public unions, which represent government workers, and private unions. When you're talking about a union in the private sector, you're talking about individuals coming together to collective bargain and possibly approaching management of a given company or industry saying they want better working conditions or hours improvements or wage improvements. And the real critical difference between private unions and public unions is that in the private sector, what a manager or a CEO can do is really governed by their budget or how much money they have coming in. There's a natural kind of cap on what's possible in regards to meeting workers' demands. That cap doesn't exist in the public sphere, right? It's really from the taxpayers, the public budget that, the income, the budgets come for public agencies and public workers. And so there's a really big difference between public employee unions and private unions. Public employee unions really are limited by nothing. And I think that that's why, you see budget deficits when it comes to the state of California or different municipalities where we have these large shortfalls because they've made promises to public workers in the midst of these collective bargaining agreements that really can't be met. And so, to take it back a bit, you have a case in the 1970s called Abood, which had to do with some workers coming forward and saying they didn't want to pay these union dues anymore because they weren't members of the union. There's case law on the books that says with collective bargaining and public unions, if you are someone who's in an industry that's represented by a union, whether or not you joined the union or not, you had to chip in money. They called an agency fee, which was a certain percentage of the total dues owed fully for a union. And the idea was in the Abood case at the U.S. Supreme Court, they said, you are, even if you're not a full member of the union, if you're in the collective bargaining unit, you are benefiting from your, being represented by the union. Therefore, even if you don't want to pay, the full union dues, it still, makes sense for you to have to pay some percentage of the normal union dues because you're benefiting from the representation. And they said, the activities that the union is engaged in that are political in nature under the First Amendment, we can't force somebody under the First Amendment to engage in political speech or advocacy they disagree with. And so unions go out and do certain political activities. It's just in the nature of what they do. Therefore, we'll only charge you for the benefit you're receiving based upon the non-political activities engaged in by the union. And so, as I mentioned, this was a case in the 1970s called Abood. It was immediately kind of decried as this, First Amendment departure that very much kind of departed from very specific bedrock, First Amendment principles. And so Abood case was on the books for something like 40 years. And there were individuals in the liberty movement and elsewhere that worked for decades trying to challenge this Abood decision under the First Amendment. And that finally kind of came to fruition in the Janus case. There was a case before Janus called Friedrichs that had gone up and been granted by the Supreme Court. And unfortunately, Justice Scalia had passed away. And so it wound up being a 4-4 split on the Friedrichs case. And so the Janus case followed shortly thereafter, just the following year, on basically the same facts. Mark Janus was I believe he worked in child services there for the state of Illinois and wound up, saying that he did not want to pay these agency fees anymore. He was not a member of the union. He did not agree with the union's activities, their political statements. He did not agree with the advocacy they were taking. They want to make these payments. And so the court granted the case and overturned that previous decision, the Abood decision. And so henceforth, going forward, the court recognized that all activities engaged in by public unions, because they're supplied with tax dollars, that's how they function, are inherently political. There's this artificial distinction the court had put up in the Abood case between political and non-political activities of public unions really doesn't exist. That's not a real distinction. And so going forward, public employees will no longer have to pay these agency fees.
So before diving into what's going on in California, describe to us the legal lay of the land after the Janus decision. Have most federal and state agencies complied? And what have been some of the issues that union members have encountered who want to opt out of paying union dues or even leave the union?
Well, it's a great question, right? I mean, it has been kind of a mixed bag. There are no agency fees, fortunately, at the federal level. That was one of the things that the court in Janus discussed, the fact that all of these bad results that the arguments had been made in the 1970s with the Abood case that would happen if people, were not forced to pay agency fees. The court stepped back and looked and said, look, the federal government doesn't require these agency fees. There are 28 states in the union that don't require these agency fees. And none of the kind of calamitous events that were foretold actually wound up materializing. And so it's been a mixed bag at the state level. You've had certain states step in and comply immediately. And, Justice Alito in the Janus case laid down a new standard and said, look, individuals have a First Amendment right to refrain from subsidizing the activities of a public union against their will. But they can waive those rights. If individuals decide they want to waive their rights and continue or begin to provide financial support to a public union, that's fine. But the waiver they make of their First Amendment rights has to be knowing and intelligent, has to be a clear waiver of their First Amendment rights. And so you had some jurisdictions look at that new standard and say, oh, well, we have to immediately stop withdrawing these fees, because we're not going to be in compliance with what the Supreme Court says the First Amendment demands. You had other jurisdictions, unfortunately, like California, step in and say, well, we're going to try to find ways around the law, right? And so some states have changed the law and said, okay, well, we'll allow you to opt out of the union, but we're only going to allow you to do that like in this one 30-day period once a year, or this one 2-week period once a year. And so if you're not just ready with your paperwork, ready to opt out, or you don't know about it, you miss your window, you're still part of the union. Some states have enacted laws or regulations where they've said, okay, we'll allow you to opt out, but we're going to require you to file like very specific paperwork and send it to like a very specific, not known address, right? And so these are really, think of these regulations in the post-Janus area by states that are resisting as kind of ways to circumvent what Janus requires. It's unfortunate, but when you step back and you consider that public unions are one of the largest constituencies for the Democratic Party, it makes a lot of sense for Democratic legislatures in certain states and their union allies to be working together to try to preserve the financial base of the union, whether it violates the First Amendment or not.
Well, to follow on that, as you mentioned, in California, we have a supermajority of Democrats in both houses. And so the legislature naturally wants to protect the interest of the unions. So in advance of the Janus decision, there were a number of bills that they passed which were intended to help the unions maintain their ranks and, of course, their coffers. So let's start with AB 119, and that was passed in 2017. And it requires a government agency to provide the union the names and other personal information from any new hires. So the rationale is pretty clear here, but could you discuss it in more detail and the work you're doing to try to roll this back?
Yeah, absolutely. So, as I mentioned, this is a pattern, unfortunately, repeated in many other states across the country, including California, wherein they're taking steps either directly before the Janus case came down or directly after, designed specifically to circumvent what's now required by the Supreme Court. So you've got AB 119, signed into law by Governor Brown and the other Democrats in Sacramento. And as you mentioned, this law guarantees union representatives access to all new employee orientations. So that means when you start a new job as a public employee, before you've even had your first day on the job, in your orientation, when usually you're just filling out paperwork for your W-2 or any other health insurance necessary paperwork, there's already a union representative there kind of hounding you to join up. And so, it's really overt kind of pressure that unions are going to be able to place on new, employees before they've even had their first day on the job. And again, this is exclusive access to these new employee orientations. It's not as if this is an open forum where different groups can come in and speak to employees about alternative services or group access they would have. Only the HR director or another representative and the unions will have access to these orientations. Now, a follow-up to this, as required by AB 119, is also requires employers to provide their new employees contact and personal information to the union so that the union representatives can follow up with the new employees personally. This includes their names, their titles, their home addresses, their work numbers, their home numbers, personal telephone and cell phone numbers, even turning over their personal email addresses. This means even if at the orientation as a new employee you decide not to join the union or support the union, you could potentially have somebody reaching out to you on all of your personal information, communicative channels, which really I think is an invasion of privacy, not only under the California Constitution, but also relevant statutes like the Information Practices Act and the California Public Records Act.
I find that last bill kind of interesting in light of all the legislature's efforts on privacy in California in the last year or so, but that's for another podcast. Another bill, SB 285, which also passed in 2017, would prohibit a public employer, in this case a government agency, from discouraging public employees from becoming or remaining members of a union. As I look at this, if I were, say, just hired as a teacher or as a worker at a government office, and I wasn't sure whether I wanted to join the union, it sounds to me like I couldn't go to the HR person and ask for more information. In other words, it seems like the union has total power over the information that I would receive under this law. We're not lawyers, but doesn't this seem fundamentally unfair? So what's some of the work that you're doing for cases like these?
I agree. I absolutely agree with you. It does seem fundamentally unfair. I think a point to emphasize here is that, I'm not anti-union. I don't think that many of the people I've worked with in this area are anti-union specifically, but the public unions have been making arguments for years in courts of law across the land and also in the arena of public opinion, saying that the services they offer benefit individual employees, and by virtue of benefiting individual employees, it also benefits the public writ large. If they believe those arguments, if that's actually their position, then they should be able to make that case, directly to employees without coercive, effects from the government, right? Without using the law as a weapon to either trap somebody in an orientation or prohibit what employers can or can't say to their employees. If they want to make that case, if there's a case there to be made of the benefits that they provide for the public, then I would encourage them to make that without utilizing kind of the force of law, right? So you talk about SB 285. As you mentioned, SB 285 prevents public employers from, quote, according to the statutory language, deterring or discouraging their employees from union membership. Now, the obvious question here is, what do these statutory terms actually mean? What does it mean to deter or discourage an employee from joining a union? Does it mean you can't tell them about their rights under the Janus case? Does it mean you can't give them information as to alternative services or organizations that can provide for them or their families? Your guess is as good as mine, and that's part of the problem with this statute is we don't know what these terms actually mean. And when it comes to the First Amendment, you also, not only can you not outright tell somebody what they can or cannot say, you can't chill their speech ahead of time. You can't give someone a reason to silence themselves for fear of government retribution. And a law like this is exactly what that does. I mean, in addition to being a content-based prohibition and therefore subject to the most stringent type of First Amendment scrutiny we have in constitutional law, SB 285, as I mentioned, appears to be impermissibly vague. So, public employers should be able to communicate, as you mentioned, with their employees about their constitutional rights and be able to do so without fear of reprisal.
So finally, there's SB 866, which in my opinion really goes all out. So among its requirements are that anyone who wants to cancel payment of their union dues must go through the union, and all communications about whether or not to join a union from the government agency must be run by the union. So it's stunning that the legislature actually gave the unions so much power. So talk about some of the details of this legislation.
Yeah, I think that this SB 866, as you mentioned, really is kind of the worst of the bunch here, right? I mean, you have Governor Brown sign SB 866 into law on the very day that Janus was decided. So I think that, we can assume quite a bit from that this was not, that those dates are not just happenstance, right? The fact that this law was signed into effect on the day that Janus was decided tells me specifically, even more powerfully, that this is an attempt to circumvent what Janus requires. So SB 866 contains a myriad of questionable new requirements and prohibitions applicable to both public employees and public employers, with the goal of preserving union power at the expense of workers' constitutional rights. First of all, public employers now are expressly prohibited from sending any mass communication, quote, regarding the right to refrain from joining a union unless it first clears that communication with the union. So you really have a union veto on communications between employers and their employees. Next, in addition to AB 119, which as I mentioned, was the public employee orientation issue, SB 866 makes this access exclusive, requiring that the date, time, and location of these orientations be kept confidential. This means if you're a party who even has an interest in possibly speaking to new employees or wants to know when these orientations are going to be held, you can't get a hold of that information. It's now been rendered secret by the unions and their allies in Sacramento. No third parties can have access to the orientations or even know when they're occurring. Finally, and most egregiously, SB 866 requires employees to be prohibited, as you mentioned, from speaking to their own employers about union-related payroll deductions. And employers are forced to rely on the union's representation regarding deduction requests. They can either request proof of what a given employee wants to do, nor ask that employee directly. Employers and employees under SB 866 are literally prohibited from speaking to each other about their union dues or agency fees. SB 866 thus implicates major First Amendment and due process concerns. Because precisely, how can someone give the clear and affirmative consent required by Janus if the information necessary to make that decision is specifically withheld from them? And so Pacific Legal Foundation, in partnership with the Liberty Justice Center, actually just on July 30th filed a lawsuit regarding this issue, representing two employees at the University of California at San Diego who would like to not be forced to pay these fees anymore. And so that's a new lawsuit filed in the Southern District Court for California, and we'll be watching with some interest in what the court makes of our arguments in regards to our clients' constitutional rights.
Well, we have our fingers crossed hearing about cases like that one. So how do you assess your chances of winning these cases in the courts? I imagine, the thought of going before the Ninth Circuit is probably a daunting one as you look down the road here.
Well, it's always a toss-up with that particular circuit, as you mentioned, for your listeners who aren't otherwise aware. The results out of the Ninth Circuit are sometimes mixed. It doesn't always turn out quite the way that libertarian or conservative-minded attorneys would like on behalf of constitutional rights. But I'm always optimistic going into cases that just judges and justices will do the unique constitutional role required of them through our Constitution, right? I mean, as a little bit of kind of a refresher, right? You look back at it, you go, Congress passes the laws, the executive branch is tasked with enforcing those laws, and the unique role of federal judges in our system is to enforce the Constitution, whether that be the separation of powers or individual civil liberties. And so when judges are reluctant to do that through deference to other branches or any other reason, that's really a breakdown in our constitutional system. So I always am careful not to try to predict with too much certainty what a given judge or justice will or will not do, but I am always confident going into cases like the one that I previously mentioned or any other case that I'm involved with here at Pacific Legal Foundation, that judges will step up to the plate and fulfill their role under the Constitution.
So we mainly talked about Janus and union power in this podcast, but could you discuss some of the other cases you're fighting here in the state?
Oh, absolutely. Yeah, unfortunately, there's no shortage of unconstitutional actions here in my home state of California. I've wondered before, been asked, why is Pacific Legal Foundation, headquartered in California? We're a national organization, so we have offices all over in D.C. and Florida and all over the place. But they said, why was Pacific Legal Foundation founded in California? And I always say, well, this is where where kind of the action is in terms of out-of-control government. So it makes sense for us to be active here in the state. So several cases that the firm is involved in, me in particular here in the state of California. One of them has to do with falconers. So I don't know if you all are aware or familiar with this ancient sport of falconry, but it consists of individuals who train raptors and birds of prey. They keep them as pets. They go out and they fly them to do demonstrations, or they hunt with them. This is a sport that goes back several thousand years. So in California, like every other state, the state requires you to have a license for the practice of falconry. That in and of itself, may or may not make sense, some minimal competence for the keeping of these birds. What doesn't make constitutional sense is that the state has attached a condition onto falconers' licenses that says, if you want to be a falconer, if you want to keep your birds and have a falconry license, you agree to allow us to enact warrantless inspections of your home unannounced whenever, however we want. And so this is a blatant violation of the Fourth Amendment based in property rights and privacy rights of private homes. The government can't just say, well, you're going to have a license. I mean, imagine if they tried to do this with a dog license or with the driver's license, right? It should make no difference that we're talking about people who happen to own birds. They can't show up at your house, heavily armed with bulletproof vests on and demand entry into your private home. That simply is not allowed by the Fourth Amendment. So that's one case we have here in the state of California. Another case we have is the Lent case. This case has to do with people who own, a couple who owns a home on the California coast along the Pacific Coast Highway. They purchased this home, and originally the original owners of the property, according to the California Coastal Commission, to get a permit to build a home, had to agree to what's called an easement along the edge of the property so that people who were up on the road could kind of have access down to the beach, right? And so in agreement with the California Coastal Commission, they said, okay, we will build this easement out so people can have access to the beach so we can have your permission to build our house. Go down the line 20 years and the house is owned by a completely different couple, right? California Coastal Commission shows up and says, hey, this staircase that you built and this fence here, this doesn't conform with our regulations. And the new family says, well, hey, we didn't build the home. We've only owned it for 5 years. We didn't know. Here, we'll give you the keys to the gate, or you can kind of make changes. We just feel like if people are going to be coming up and down and going to the beach, they should at least have a staircase and a gate to make sure they don't fall into this next door gully. So the California Coastal Commission hits them with a $4 million fine for not acting quickly enough in conformance to their demand letter. So there are cases like that all over California. And Pacific Legal Foundation was founded in the 1970s. We've been around for over 40 years now, and our entire organization exists purely to take on cases like this, pro bono cases. We don't charge our clients for anything, specifically to defend their constitutional rights and the constitutional rights of all the citizens, not only of California, but across the United States.
We call our podcast Next Round because most everyone here loves to relax with a glass of wine at PRI, and of course we're just a stone's throw away from wine country. So what do you do to relax in your off hours when you're not hard at work fighting for our rights in the state?
Oh, well, I'll tell you, I'm not much of a drinker, but I am a big movie guy, right? And so when I'm not in the office here defending constitutional rights, you can usually find me in the hallways of the office or on some message board somewhere arguing about the nuances of the Star Wars trilogy or Star Trek or some other dorky style of a movie feature. So that's what I usually do is I'll relax, I'll get a nice steak dinner, and I'll either kick back at home and watch the latest Netflix film, or I'll head to the movie theater.
Thanks so much for joining us, Tim.
My pleasure. Thank you.
Special thanks to our guest, Tim Snowball. And if you're interested in learning more about the Pacific Legal Foundation, go to their site at pacificlegal.org. And if you're in the San Francisco area, join us for a luncheon with National Review's Andrew McCarthy on August 14th. The details are on our website at pacificresearch.org. If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, or TuneIn. And please do us a favor and give us 5 stars. You can also listen to our podcast on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Ichon. We hope you'll come back again for Next Round with PRI.